Okay, at this point, we have to bring in today's guests. We are still talking all things Duterte. We've got Dr. Fadi El Abdallah joining us via Zoom from the Netherlands. He is the spokesperson and public affairs unit head of the International Criminal Court. Good afternoon, Dr. Abdallah. Can you hear us okay?
Good afternoon, Doctor.
Good afternoon, Doctor.
Good afternoon, everyone.
Good afternoon. Thanks for making time for us. My name is Regina. In the studio with me is Ronald, and joining us via Zoom is Amy. We recognize that you've been asked the question about jurisdiction numerous times already, so I don't want to dwell into that. So I'd like to look forward, if that's okay. So let's look towards the confirmation of charges hearing. And I think by now, most people here have a basic understanding of what would happen at the confirmation of charges hearing, but could you walk us through the procedure, what it'll be like, and give us an insight into why it was scheduled 6 months down the road? Initially, we were under the impression that it would have been scheduled within weeks after the first hearing.
Well, first we need to explain maybe shortly what is a confirmation of charges hearing. It's not a trial, it's not a mini trial, it's a phase that allows the judges to decide whether or not the case should go to a trial. So when we have an arrest warrant, that means that the judges have only seen the evidence presented by the prosecutor without counter-argumentation by the defense. So the confirmation of charges hearing is the moment for the defense to present its own argumentation to kind of test the evidence that is presented by the prosecutor. And that would allow the judges to know whether or not the case should move to a trial. Also, it's the moment where, for the first time, the judges would be also listening to the legal representation of the victims that would be authorized to participate in the hearing. Victims are not witnesses. Witnesses is a different category. Victims here are participants to the proceedings to explain their own points of views and their own observations and legal arguments. But they are not there to present evidence or to add charges against the suspect. They are only participating to make the voice of the victims heard inside the courtroom. But they are not necessarily witnesses, as I mentioned.
So, Doctor, it's like an arraignment. It's like an arraignment,
well,
yeah?
I don't know. In each country there are different systems. So I don't know what's exactly the national system in the Philippines. But for us, it's a kind of a filter to know whether or not we should go to a trial or stop the case at the pre-trial level. Now, when I mentioned that gives you already an idea why did we need at least 6 months between the initial appearance and the confirmation of charges hearing, for 2 reasons. The first reason is that, of course, the prosecutor needs to provide the defense with the evidence on which he intends to rely during this confirmation of charges hearing. It's not all the evidence that the prosecutor has, but it is the prosecutor's evidence that he considers that enough to convince the judges that the case should move to a trial. But for that, we need to respect the rights of the defense, the presumption of innocence, but also the right to have enough time and facilities to prepare for a meaningful defense, meaning to be able to receive this evidence in a meaningful way, in an organized way, to investigate this evidence, eventually to find additional evidence that maybe the defense wants to present to the judges. So this takes time to disclose the evidence to the defense, but also to allow the defense the time to check all this evidence. And the second reason, as I was mentioning, is the issue of the participation of the victims that also needs to be organized. We need to communicate with the potential victims what are their rights, how to seek participation in these proceedings, and actually fill the applications and give the judges the time to decide on which applications would be within the parameters of this specific case. Because we are speaking about the participation of victims that are concerned by the parameters of this case specifically. So that takes a certain amount of time. That's why we need to organize the confirmation of charges a few months after the initial appearance.
When will the appeal for the interim release happen?
Ami, go ahead.
Dr. Abdallah, we were told that the Duterte camp is planning to apply for his interim release. I've been trying to find out the circumstances under which this could be granted. Could you tell us more about it? I understand they have to be extraordinary circumstances for this to be granted.
And when will that happen?
Well, I will not speculate on the outcome of such a request. If it is submitted to the judges, it will be for the judges to decide on it. The general legal framework is that, of course, a suspect is presumed innocent. And for that, there is a possibility to be free. The arrest has to be justified. And the judges can consider that the arrest is justified if we consider that the suspect would not be voluntarily cooperating with the court and appearing before the judges when they order so, or that the suspects and his potential network would be putting witnesses at risk or creating obstacles for the investigation, or if there are circumstances that shows that the suspect might be continuing to commit crimes falling under the ICC jurisdiction. So these are the reasons that needs to be, at least one of them needs to be there to justify the arrest. So if the judges consider that potentially if there is a request for an interim release and that there is a state that is willing to accept the release of a suspect on its territories and to implement any measures that the judges may consider necessary to ensure that the person will be appearing before the judges when ordered, that there will be no obstacles or risks created for the investigations or for the witnesses, and that the person will not be continuing to commit crimes, then it's a possibility for the judges to grant an interim release, a conditional interim release. But of course, it will be for the judges to decide on that. So we should not speculate. If the defense presents such a request, the judges will consider what is possible and what is to be granted in this context.
Ronald.
Yeah, from your vantage point, Doctor, what is the difference of this case compared to other cases, previous cases in the ICC? Aside from probably this is the first Asian to be tried in the International Criminal Court, what are the differences?
Well, for the ICC, all cases are serious and all cases have to be of a sufficient gravity. This is a main element. And we consider that it is our duty and our mandate to bring justice to the victims and to endeavor to uncover the truth about the allegations with the full respect of the rights of the defense, of course. Now, it is indeed the first case that in which there is an arrest related to a person from Asia, yes. But on the substance of the matter, we are always speaking about serious crimes, crimes against humanity, war crimes, or genocide. And this case or other cases, they are all treated with the same respect, full respect for the victims and for the defense's rights.
As you said,
During the submission of the Duterte camp before the court, our former executive secretary said that the ICC wants a prize catch in the person of the former President Duterte. And this criticism has continued in the Philippines. If you might not be aware of it, we just want to get your reaction to this.
and actually to add to that, the longstanding criticism is that the ICC has not been able to apply international law evenly and fairly, and that there's a perception that you're targeting, countries in the global south. Again, your reaction, please, Dr. Fadi.
Well, first, the ICC can only apply the law. So when there is jurisdiction, when there are evidence about a certain crimes, it is our duty to be applying the law and bringing cases and trying to bring justice to the victims. That is our mandate and that is our duty. And we do apply that evenly over all the conflicts on which the ICC have a jurisdiction. So we are not looking at any profiles. We are looking at the evidence and on what is the applicable law in a certain situation. Now, if you look at the list of the suspects before the ICC and the defendants before the ICC and the list of the investigations that are before the ICC, you will notice that it's in 4 different continents. It's related to conflicts in Afghanistan, in Philippines, in Venezuela, in Africa, in Ukraine, in Palestine, and there has been arrest warrants issued against a variety of suspects in all these different situations and circumstances. So there is no approach that is focused on a certain region or on a certain category of states, but it is actually where we have jurisdiction, we have the duty to bring justice to the victims within the legal framework of the ICC.
You talked about the principle of assumption of innocence until proven guilty earlier. On the one hand, you have that, but on the other hand, the suspect, the subject is detained without option of bail until such time that, until the confirmation of charges hearing. So how do we reconcile that? How does the principle of fairness for the accused apply here?
Well, first, at a pre-trial phase, we are not calling them accused, we call them suspects. And of course, there is a presumption of innocence. And that's why, as I was just mentioning to your colleague, the principle is that the arrest has to be justified. So we don't have a system of bail, but we have the possibility for a conditional interim release. And this is possible, but only if there are measures that can mitigate the risks of a person staying at large, not cooperating with the ICC, or putting in danger witnesses or the investigations, or eventually continuing to commit crimes. So the principle of the presumption of innocence means that the arrest is not the rule, it's actually the exception and has to be justified for each case, and the judges would always look at what are the justifications for the arrest and eventually the justification to keep the suspect in detention, and whether the reasons are still there or have changed.
Of course, Doctor, every case may be different from other cases. But do you have a ballpark figure on how usually the cases, how long the cases happen until conviction or non-conviction? Is it 3 years, 4 years on an average?
Well, I think we should not speculate about the trial. We are still at the pre-trial phase. We have to respect the presumption of innocence, and we have to see what would be the judge's decision on the confirmation of charges itself. Because if no charges are confirmed, the case would stop at the pre-trial level and it will not go ahead. So that's what I was saying, that the confirmation of charges is a kind of a filter to know whether or not the case should move to a trial phase or not. And normally, after the confirmation of charges phase is closed, the judges would have a 60 calendar days deadline to issue their decisions on the confirmation of charges. If one or more charges are confirmed, then the case moves to a trial. If none, then the case would stop at the pre-trial stage. Now, for a trial itself, in the eventuality that there is a trial, the length of the trial depends on so many different factors. Some trials took only a couple of months, others took several years, because it depends, of course, on the nature of the crimes, on the number of the charges, on the number of witnesses that needs to testify before the judges, on the different requests from the different parties. So it's practically impossible to predict how long would be a trial if we get to a trial after the completion of charges.
So to recap, the decision on whether or not the case will proceed could take 60 days after the confirmation of charges hearing.
Yes, that's a general rule. Of course, the judges may give additional time for the parties to complement in writing their argumentation that they would have presented during the confirmation of charges hearing, which is only a matter of a couple of days normally. So then the 60 days deadline will start running after the written submissions, that then it is the closure of the confirmation of charges phase.
Is there an appeal
Doctor, the judges the judges who issue the arrest warrant are not necessarily the ones who will be trying the case, right? It will still be raffled off?
Well, the judges that are dealing with a pre-trial phase, in case they confirm the charges and the case moves to a trial, there will be not the judges that will be in the trial chamber. The trial chamber will be constituted of 3 judges, different from the judges of the pre-trial chamber that is looking at the case currently, and that's in the eventuality that the case would move to a trial. And that's, of course, we have to wait for the decision of the judges to know.
Will there be an appeals process composed of, again, different judges?
Yes. So in case there is a request to appeal a certain decision, whether a pre-trial decision or eventually a trial chamber's decision, the appeal is decided on by an appeals chamber that is composed of 5 judges, different from the judges that were in the pre-trial and eventually in the trial chamber. So yes, for each phase, it's a different set of judges that will have to decide in order to make sure that there is always this impartiality of the judges.
Dr. Fadi, when Duterte's common-law wife and daughter arrived at The Hague on March 26, they said they were not immediately granted entry into the detention facility, and they also brought suitcases of his personal clothing and other personal effects, but these were also not allowed in. I wonder if you could give us more context on that. What happened there?
Well, unfortunately, I cannot, because everything that is related to the private aspects of the life of a detainee has to remain confidential. It's a respect to their privacy and to their family life. What I can say is that the detention center has its own rules. It's not a prison. It's a detention center that allows a certain number of visits, mainly for counsel defense teams and also for family. But it has to be, of course, according to a certain schedule and to certain rules that needs to be applied there.
Is bringing in personal effects allowed to begin with? I mean, just generally speaking.
And again, I cannot discuss the issues that are related to the private aspects of the life of the detainees.
Okay, fair enough.
Doctor, this past 2 weeks since the arrest, there has been demonstrations of public support and sympathy for the accused ex-president. Does this usually happen at the ICC? Because from my little knowledge of the ICC, I don't usually see this gathering of people in support of an accused. In the past, does this happen?
Well, first, Mr. Duterte is, for us, a suspect. He's not an accused. We only use the term of accused if there are confirmation of one or more charges. And second thing, yes, I have a long experience at the ICC, and I have seen many different cases in which there was also a large support for certain suspects or accused. It is their right. We fully respect the rights of the people to show their opinions and to express their solidarity with certain individuals. But what is important to highlight is that the ICC judges can only decide based on the applicable rules and on the evidence that is presented to them by the parties in the proceedings. So a public show of support, of course, is something that we respect, but it's not something that is taken into account by the judges in a judicial process.
Dr. Hungary is withdrawing from the ICC. Is this impacting on the work of the court in any way?
Well, first, at this moment, there is no withdrawal. As you know, we fully respect the sovereign right of each state to decide whether or not to be or to remain a member of the ICC Rome Statute. There are rules that are applicable, including that a withdrawal becomes effective only 1 year after the deposit of the withdrawal instrument with the United Nations Secretary General Office. You know that because it was already the situation for Philippines in the past. We still hope that this will not happen for Hungary and that there will be a possibility to change this position. We believe that there is a need for more states to be states parties, more solidarity in the global fight against impunity, more commitment to the international accountability mechanisms, because we are facing global challenges, all of us, and the only way to deal with the global challenges is actually to have international mechanisms where all the states can come together and work together.
How about the punitive threats of U.S. President Trump, the most powerful president in the world at this point? Are they already being implemented? His threats about freezing accounts, his threat about banning.
He's
Yeah,
gone so far as
Yeah.
issue an executive order, if I'm not mistaken.
Yeah, banning judges or prosecutors from the U.S. For entering the U.S. Are these punitive actions already implemented by the most powerful president in the world right now?
Well, in relation to the ICC relationship with the American administration, you know that there has been several changes over the past. There was already a few years ago with the first Trump administration, there was already sanctions that were imposed back then on the previous ICC prosecutor and on some of her staff employees as well. Then this was changed and lifted in the next administration. Currently, there is, as you mentioned, an executive order, and there is one designation of sanctions against the current ICC prosecutor. Of course, the ICC is aware of all of that, and we are taking all the necessary measures to mitigate any potential impact of such decisions on the ICC work. It's our duty and our mandate to continue working for justice and for the victims that deserve this justice. And we will continue to do that independently of any kind of political or otherwise attempts to pressure the court. The court can only deliver on its mandate, applying the legal framework that was given to us by the states parties and working towards a more just world.
Does that include offsetting measures in case the U.S. pulls out funding support?
Well, the U.S. is not a state
that's
party
right.
to the ICC, and thus the U.S. is not funding the ICC in any way.
Doctor, our current president has said that, well, he was asked about it, and he said that he is studying the possibility of the Philippines rejoining the Rome Statute. Has the ICC received any word, anything, any rumor, or any
Indication.
any message from the Philippines that we might actually be rejoining the ICC?
Well, I don't have access to behind-the-scenes potential or eventual discussions, so I cannot. I'm not in a position to confirm this, but it will be very welcomed if Philippines and all the other states join the ICC Rome Statute. As I was mentioning, impunity is a big challenge on the global level, and the only way to tackle this global challenge is by a global fight against impunity.
I want to come back to that initial appearance by Rodrigo Duterte to the pre-trial chamber court. At that time, his lawyer, Salvador Medjildea, made a manifestation saying the arrest was an extrajudicial rendition, essentially a kidnapping. That part was unexpected. What did the judges make of that? Do we know?
Well, if I understand well, there is a discussion about this before the Philippines court. So first, we need to see what would be the decision there. And if there would be a request related to this matter before the ICC judges, it will be for the ICC judges to decide on it. At this moment, since there is no decision, I'm not in a position to elaborate further or to speculate on what might be if there would be eventually a request.
But is that a non sequitur? Even if there's a case here, will that affect the jurisdiction of the ICC? Because as far as the little I know is that the ICC doesn't care about what happened here. What they care about is the evidence during the trial or the confirmation process. Is that relevant to the ICC case, whether there are illegalities or whatever here in the Philippines?
Well, again, I will not speculate. If there would be a consideration that there was an unlawful arrest or detention, it would be for the judges, if they will receive a request to that effect, to decide on what is the impact of such matter on the ICC proceedings.
Okay.
Doctor, can the ICC provide protection to witnesses and the prosecution lawyers? I ask because the lawyer one of the assistants to counsel in the Philippines and her clients, who are relatives of victims of the drug war, are saying that they are being subjected to harassment and even physical threats of physical violence in the Philippines.
Well, first we need to make a distinction, a clear distinction for everyone between victims and witnesses. Witnesses are individuals who are called by either the prosecution or the defense or eventually the judges to provide a testimony, a certain information that might be valuable for the judges. And in the vast majority of the cases, witnesses are not victims. We can speak about insider witnesses, about expert witnesses, all different types of witnesses. Only a very limited number of victims may be at the same time called to testify. So victims in the vast majority are not witnesses, and witnesses in the vast majority are not victims. Now, of course, there is a protection program for the witnesses and eventually for other individuals if they are at risk because of their interaction with the ICC. But this type of protective measures depends, of course, on what is the level of risk that they may be facing and what can be done in order to mitigate this risk. And in all our interaction with victims or with other individuals, there is a matter that is very important, which is confidentiality and discretion. And of course, the court puts all the necessary measures to ensure the anonymity and that the identity of the witnesses and eventually of the victims are not revealed in a way that may be causing them to run a risk.
How do you do that, Doctor, knowing that the limits are resource-wise and organization-wise of the ICC is not that huge? Can you, for example, if there are a lot of people applying for protection, does the ICC has the power to request member states to support or protect these individuals?
Well, first we need to assess what is the cause of the risk and what is the level of the risk. For people that are at risk because of their interaction with the ICC, then of course the ICC would have a duty to offer a protection to them. And then we need to see what is the level of the risk and what measures are necessary to ensure that they are protected. Sometimes just keeping confidentiality, discretion, and anonymity would be sufficient. In other cases, we may need to have other measures, whether in the location where they are or to bring them to another location. Of course, there is a specific protection program at the ICC, and of course, this is done in coordination and with the support of the states.
Talking about power, does the ICC have the power to order a freeze on Duterte's assets if it comes to that?
There is a possibility for the judges to order the freeze of assets for suspects. Now, it depends, of course, on the implementation, on the obligation of the states to cooperate, etc. But yes, there is a possibility for the judges to order a freeze of asset if it is necessary, for example, to ensure the payment of reparations if we get to a reparation phase, which can only be discussed after a trial and after a potential conviction. If there is no conviction, we are not discussing reparations. But it can also be ordered to ensure that this possibility is open. It can be also used to cover the expenses of the defense of a certain suspect. So yes, by law, there is a possibility for judges to order a freeze of assets.
And how would that play out? Would you then need the state party to cooperate? Or in this case, the Philippines is no longer a state party, so how would that work?
Well, I would not enter into a speculation about this. If there will be a decision from the judges, then of course we would seek the cooperation of the relevant authorities.
Okay.
Theoretically,
Doctor, is there a reasonable chance that there will be more arrest warrants in connection with the war on drugs?
Well, what I know is that the ICC Prosecutor Office is continuing its investigations, and if they consider that they have enough evidence against other individuals, it may be brought to the judges. And then the judges will have to decide whether or not to issue arrest warrants.
Theoretically, Doctor, if a suspect becomes formally accused and will be put in detention in the ICC detention center, can he intermingle or interact with other detainees, or will he be separated like in a solitary confinement?
No, it is possible for the detainees in the ICC detention center to actually meet each other unless there is a specific reason or order by the judges. Like, for example, in previous cases, we had several detainees that were related to the same case or to the same alleged facts. And it is possible then for the judges to order that these two people do not meet. But the general rule is that, yes, the detainees in the same facilities can meet each other.
On March 21, the ICC announced that the prosecutor has already turned over 181 pieces of evidence to the defense, but it's also our understanding that there might be more. I wonder if you could give us more insights on this, Dr. Fadi. How much more, and what kind of timeline are we talking about?
Well, unfortunately, I don't have this type of information because it's a matter for the Office of the Prosecutor to disclose the evidence that he intends to rely on during the confirmation of the charges to the defense. But the total amount of the evidence and the timing of the disclosure is something to be dealt between the parties under the supervision of the judges, and I don't have access to this information currently.
Okay.
Just in case, Doctor, that there's enough strong evidence to warrant another international warrant to another accused Filipino in relation to these crimes against humanity, and that suspect goes into hiding, usually how does the ICC confront this eventuality? Because for now, we have several, I think 14 or 15 people still at large who have been issued international warrants by the ICC. So what do you usually do in these cases?
Yes, there are several individuals and suspects against whom arrest warrants have been issued that remain at large. And of course, the ICC does not have its own police force or army to arrest them. The ICC relies on the cooperation of the states. States that are parties to the ICC Rome Statute, they have a legal obligation to cooperate and to arrest these individuals if they are on their territories. States that are not parties, they may decide to cooperate on a voluntary basis, and that would be a great thing because it will show their commitment to the international law.
Okay.
Doctor, since the arrest of former President Duterte, has the ICC received any communication, any form of communication from the Philippine government?
Well, again, I don't have access to any confidential material, so I would not be able to confirm or not this type of information. All public documentation are made available on our website, of course.
Okay, we're going to have to leave that there. I think we've taken up much more of your time than we'd asked for. Thank you so much for your answers, though, and your insights. That was ICC spokesperson Dr. Fadi El Abdallah, also the head of the Public Affairs Unit of the ICC. Thanks very much.
Thank you, Dr. Fadi.
Thank you, Doctor.
Thank you. Have a good day.